Okay, hi there, Dr. Matthew J. Trom here. This presentation is in the Intellectual Property for Engineers module of the 4501 course, and this particular presentation is going to be on patents for engineers. As you guys know, having seen my asynchronous videos before, the way that I do this is I tend to speak for about 15 minutes and then give you guys a break and then pick up with the slide deck wherever it was that I left off, and we'll just keep doing that until we exhaust the entire slide deck. So we'll go for about 15 minutes here and then give you a break and pick it up again and so forth. Okay, so before I jump into the meat of the presentation, just a quick disclaimer. So I am not a lawyer, and this lecture is not meant to be legal advice. The goal here is to educate you guys on the four foundational types of intellectual property, so that you know enough as you transition into professional practice, that you can be beneficial and helpful in meetings where intellectual property is talked about. But please, before you make any legal decisions, seek the advice of a true bona fide lawyer. I am not one, and this is not meant to be legal advice. In addition, the legal definitions and some of the content in the slide deck is borrowed from my colleague, Professor Danny Sokol, who is a professor of law over in the Levin College of Law at the University of Florida. And I am using the content here and the definitions with Professor Sokol's permission. All right. So we've seen this before in the other intellectual property module presentations, but let me just quickly go over it in case this is the first one you're watching. So what is intellectual property? According to the according to the World Intellectual Property Organization, intellectual property, or IP, is what it's referred to. So IP refers to creations of the mind, such as inventions, literary and artistic works, designs, and symbols, names, and images used in commerce. IP is protected by law, which enables people to earn recognition for financial benefit from what they invent or create. And then the really important thing that I kind of want you to take away is the second sentence, which is the idea that by striking the right balance between the interests of innovators and the wider public interest, IP legal systems aim to foster environments in which creativity and innovation can flourish. And effectively what that means is giving the creators some period of time where the creative works are protected and they can commercialize them and capitalize on them, but eventually allowing those creative works to move into the public domain so that everybody can benefit from them, and so that new inventors can sort of remix and reuse those creations to generate new technology and continue progress moving forward. And I think of all the different types of intellectual property protection, I think patents do this the best. You guys know from my copyright presentation, I think copyright is the worst example of this, where basically anything that's copyrighted is copyrighted forever. But patents do a really good job of sort of balancing the needs of the inventors with the needs of the commons. So we'll see in the presentation here how that's done. And just as a quick reminder, there are four principal types of intellectual property: trade secrets, copyrights, patents, and trademarks. And so, depending on the order in which you've watched my videos, you might see these in slightly different order, but you can always come back to this slide, which gives a comparison of the different types of intellectual property across a series of metrics: benefits, duration, weaknesses, and required steps. And so you could just, once you have the static slides, which you can download from the course website, you could just take a look at this to very quickly be reminded of what the four IP types are, what they do, how they function, how long they last, how to get them, and so forth. Okay, so with all that covered, let's jump into the lecture. So I'm going to talk about what a patent is, share with you four different types of patents, and then a couple of examples of what I call IP blending, which is the utilization of kind of unexpected definitions of patents and or patents in addition to other types of intellectual property protection blended together to create IP protection instruments that are stronger than the individual components themselves. So we'll see how that's done. We'll talk about what can and cannot be patented, patent infringement and preserving patent rights. And then you guys know me by now. You know that I can't get through a single intellectual property presentation without telling you guys a war story. And so if you stick around to the end, I'll tell you a little bit of a war story about something that I think was repatented successfully and maybe possibly should not have been. So anyway, if you stick around to the end, you'll get to hear that war story. Okay, so let's jump into what is a patent. So according to USPTO, oh, and by the way, USPTO is the U.S. Patent and Trademark Office, so it's an office in the executive branch of our federal government here in the United States. So according to USPTO, a patent is the grant of a property right to the inventor to exclude others from making, using, offering for sale, selling, or importing an invention. And I highlight exclude others because a patent doesn't actually give you the right to make, use, sell, or import these things. It gives you the right to exclude others. And it's subtle, but it's an important difference because there's no expectation when you hold a patent that you're actually going to use it for any sort of commercial benefit, right? And in a way, you could get a patent and then you could use it to forestall the advancement of technology for the lifetime of the patent. Now, a great example of this that's, I think, pretty relevant to our 2021 world, that's what I'm giving this presentation, is 3D printers, right? So now everybody has a 3D printer basically at home on their desktop. It's a pretty standard, ubiquitous additive manufacturing technology, but the original invention of the 3D printer occurred in the late 1980s, and the inventor was a guy named Ellie Sachs, who's a professor at MIT, mechanical engineering professor. I know him. I worked with him when I was a student there. And he did not, race forward with the commercialization of 3D printing technology, but because he was the holder of this patent, he was able to basically exclude other companies from jumping into that space, at least for the first 20 years. And so about, 2005 sort of time frame, 2006, those 3D printer patents began to expire, and then companies like Prusa, MakerBot, and so forth have now jumped into this space because those patents have expired and those technologies are no longer excluded. They're part of the public domain now, and so other companies have been able to jump into that space and begin to profit from those innovations. But if Professor Sachs had gone a different direction and tried really hard to commercialize 3D printing, we might have seen like the onset of desktop manufacturing and 3D printing capabilities, almost 20 years sooner than it actually happened because the technology did exist in the late 80s, early 90s. So that's just an example of a patent holder basically excluding others from a space rather than commercializing a technology because he or she happens to hold a patent. Okay, so that's the USPTO definition. Now, in theory, if you hold a patent, you're called a patentee, and you can stop a competitor from commercializing a technology that infringes upon your patent, even if they come up with the idea independently. Now, this is the key difference between trade secrets and patents, in that if you've seen the trade secret presentation, you know that if somebody else infringes upon your trade secret and they're able to demonstrate that they came up with that innovation on their own without nefarious purposes, without industrial espionage, or lying, cheating, stealing in some way to get a hold of your trade secrets, then your trade secret is basically bunk, right? It's only defensible to the extent that nobody else knows how to do what you do. Whereas with a patent, in this context, it's stronger because once you hold a patent, even if a competitor figures out how you do what you do, they are still excluded from benefiting commercially from that discovery, so long as you're the original holder of the patent. So patents are stronger than trade secrets, at least in this one respect. Now, the trade-off, of course, is that patents do require public disclosure of the invention's embodiment. So the moment that you are granted the patent, you basically tell the entire world how you make the sausage, right? How you do what you do. And that, as we'll see in a second, can have some complexities and some complications. But at least in the United States, when you get a patent issued, it lasts for 20 years, right? And provided you have the financial means to defend your patent, you can prevent anybody else from profiting from your creativity for that 20-year period, and hopefully use that period of time to commercialize and capitalize on the fact that you are the owner of this particular invention. So, U.S. patents are effective only within the United States, right? Which is why this public disclosure thing is a little dicey, because if you patent something in the United States, you basically disclose to the entire world outside of the United States as well how you do something, and somebody from another country can commercialize your idea, can basically steal your idea, steal your patent, and commercialize it and market it in some other country. And so long as they're not importing that innovation into the U.S., there's nothing you can do about it, right? Because only the patent only applies within the national and territory boundaries of the United States. So that's one of the weaknesses of patents. Another one is that once the patent is issued, the patentee must enforce the patent without the aid of USPTO, right? So the government is not going to help you enforce your patents. You have to have the due diligence to be able to constantly be looking around in the market to see if anybody else is infringing, and to have the deep pockets to take that infringer to court and actually win in a court of law if you feel like your patents are being infringed upon or violated. You don't get any help from anybody other than just the fact that you happen to own the patent, and so that can create complications as well, especially for smaller patent holders. And then finally, a patent does not free inventors to infringe on similar patented intellectual property. And there's kind of a funny example of this idea that patents do not enable inventors to infringe on similar patented intellectual property in the world of refrigerators, and in particular French door style refrigerators that have a built-in ice machine in the door. This technology has been a thorn in the side of the refrigerator industry ever since it basically was created. It originally started out as, if you think about the Cano model, kind of a customer delighter, right? So not part of normal French door refrigerators, but now enough manufacturers have added this ice maker in the door capability that it has moved from being a customer delighter to a performance attribute. And now to sell a French door fridge, you basically have to have an ice machine in the door. Except because it's a relatively new innovation, different companies patented various different techniques to put the ice maker in the door, and it turns out that there's only really one company that figured out how to do this in a way that truly works, which is LG. So here's just a snapshot of the inside of an LG fridge. You can see they've got the ice maker. All the components are all built into the door. The ice is stored in the door. There's a nice kind of clear container where you could see the ice, supply sitting there, and it's just dispensed through the door, and everything is contained in the door, and it's wonderful. They've got this idea patented, and so all these other poor companies who are trying to sort of keep up with this now Cano model performance attribute for French door fridges have come along and come up with a bunch of various alternative ways to put this ice maker capability in the door. So here's Samsung's version of it. I happen to own a Samsung fridge, so they've actually got the ice maker built into the housing of the fridge, and it feeds ice into a little hopper that then feeds ice through the door to the end user. There's the Whirlpool solution, which is kind of the same idea. They've got some of the same elements as LG, but they still make the ice in the main body of the refrigerator, and then dump the ice into this hopper and then pass it through the door. And it turns out, if you sort of read the popular literature, all of these other French door refrigerator manufacturers are basically just riddled with complaints about how their ice makers don't work. And the reason for that is because LG has patented this particular technology, this particular configuration. And so even though Samsung, Whirlpool, GE, all these other companies, have patented sort of similar competing technologies, just because they hold a competing patent doesn't mean they can start infringing upon LG's patents. And the situation has gotten so bad, right? So you can see here's just just a a lady who owns a fridge it looks like she's trying to clean out her ice maker with a vacuum cleaner or something like that. Who knows what she's trying to do there? But trying to fix this broken ice maker. The situation has gotten so bad that a lot of these companies have just given up and said, okay, we're just going to license the intellectual property for how to make an indoor refrigerator, an indoor French door refrigerator ice maker from LG, because it's less expensive to just license the technology from LG than it is to try to figure out ways to work around their various patents. And so, for example, in June 2019, LG and GE, General Electric, announced that LG was going to license their quote unquote advanced refrigerator technology to GE appliances, which really just means that GE can now use this indoor or inside door ice maker invented and patented by LG, and hopefully get itself out of all of these problems with kind of these alternative technologies for indoor French door ice makers that don't work. So anyway, just a kind of an interesting example of how that would work in the world of patents. Okay. We're right at 15 minutes, so let me stop there. And when we pick it up again, we'll talk about types of patents and IP blending. So see you in just a bit. Thanks.